And I'm really delighted to welcome Carwyn Jones here to the college. As I said, we had hoped to get him here maybe for a week, maybe even for 2 weeks, since his work is so interesting and so related to questions about Indigenous law, Indigenous philosophy and reconciliation in Australia. Carwyn is a Māori scholar and currently he's at the Faculty of Law at the University of Wellington. And next year he's very soon actually, Carwyn, about to take up a role as Program Director of Mori Law and Philosophy in Te Herenga Waka, a Maori tertiary institution north of Wellington. That sounds fascinating. Carwyn is extremely well known around the world, as well as in this part of the world, for his work on Indigenous legal traditions and also on the Treaty of Waitangi. He's the author and editor of a range of books as well as many articles, and he's also the managing editor of Legalities, the New Zealand and Australian Journal of Law and Society. So he's obviously working closely with people from both sides of our particular channel. So Carwyn is going to speak today on Rekindling the Fire, Renewed Recognition of Maori Law in the New Zealand Courts. Welcome, Carwyn, and we look forward to hearing what you have to say.
Thanks, Des, for that introduction. Tēnā koutou katoa, ngā mihi nui kia koutou, or greetings everyone. And I just want to begin by acknowledging the places we're all coming from and the lands we're all on, and thinking about the people of those lands, including those who have gone before and those still to come. So I'm going to talk a little bit about the recognition of Māori law in the New Zealand courts, and I'll leave hopefully plenty of time for some discussions and questions. But I've just see if I can get onto the next slide there. So what I thought I would do just very briefly is talk a little bit about Māori law in relation to land and authority as a key strand of what's actually coming through the courts at the moment, and then just point you towards some recent cases. I've got a bunch listed on the slide, but I won't intend to go through all of those in detail, but just identify some themes for you around the way in which Māori law is being addressed in the New Zealand courts increasingly, and you'll see that many of the cases are from the last couple of years, and being dealt with as law and being drawn on as a source of New Zealand law in quite an interesting way, and in quite a different way to the way in which it's been recognised previously. And that's also raising some questions about how then you manage Māori law, and in particular, who has the expertise and indeed the authority to speak on matters of Māori law, and so how you manage that within the framework of the New Zealand state court system. So that's essentially where I thought we would go in the time that we have. And as I say, I'll be touching on some things quite lightly or quite briefly, but happy to explore some of these matters in discussion with you later. Okay, so I thought one of the things that I wanted to talk about is just a little bit about Māori law and the nature of Māori law and some key ideas about land and authority. One of the things I want to stress is that the kind of interesting piece about these recent cases is that these are not kind of land title cases. They're primarily not simply about determining customary title to land, but they are involving questions of the authority that goes along with being the people of that land. And so I just thought I would tease out a little bit what I mean there. So first of all, in terms of just thinking about Māori law, since the 1860s, we've had in New Zealand essentially a statutory regime for recognising Māori customary title, and initially set up as a native land court, and it's now known as the Māori Land Court. That engaged in a process of identifying who held the customary title, and then transforming it into an individualised title, a freehold title. And so most Māori land today, there's still a particular category of Māori land, but most Māori land is held in a freehold title rather than in a customary title. The Native Land Court worked with ideas from Māori law about how you would identify who held the customary title, and primarily you can sort of summarise that in thinking about ancestral connection as being the key criteria, but then thinking about how you maintain that connection or tend to that connection as being important also for determining your rights and obligations, and how they'll be recognised. And a key concept that gets used there is this idea of ahi ka roa, and that literally means the long burning fire. So it's very much an idea about, in order to assert rights in relation to land, you need to demonstrate that you have maintained a connection with that land. And this becomes very important in terms of where people have had periods where they have been dispossessed of their land, and so before the arrival of Europeans and British settlers here, various Māori groups were jostling over areas of land in some parts of the country, and even at those times when people were pushed off areas of land, the rights that the incoming group had, if that was just an assertion of military might, then the rights that you had to that land remained pretty fragile, and those people who had been dispossessed of that land, if they had had a long connection to it over generations, would retain the ability to reassert those rights. And so it's really that ancestral connection and that tending to the connection to the land happens over generations. And so your strongest claim to the land is one in which you can demonstrate a long connection of your ancestors and a long use of that land as well. Now, so that's all very much in the context of thinking about land rights. But the concept that I really wanted to come to and think about in the context of these recent cases is this concept of mana whenua. So whenua is land, and mana incorporates ideas of authority. And so what we're talking about here is both authority over the land and in relation to the land, but also the authority that comes from the land as well. And this concept of mana whenua is one which is becoming increasingly prominent in some of these cases that I'll come to in a moment. And one of the things that I thought might be useful to think about in the context of this discussion is, what the implications of the New Zealand courts engaging in discussions about mana whenua and recognising mana whenua are in terms of an exercise of authority. So this is not simply talking about title to land, but thinking about what's the authority that comes along with being the people of that place, and how that gets drawn on as a source of New Zealand law in some instances, as we'll see. So that's really the kind of interesting shift that I think you can see in these recent cases is a movement to really be engaging with Māori law as law. So it's no longer a matter of proving a particular customary practice, but it's thinking about how the New Zealand state legal system, and particularly New Zealand common law, might be able to draw on Māori law as a source of law as well, as applicable law in some instances too. So I'll just touch on a little bit of, hopefully tease out a little bit of what I mean there by picking up on some of these recent cases. As I say, I've listed a bunch here, and I don't intend to go through them all in detail, but just to give you a flavour of some of the trends that are happening here. And in fact, the first case that's listed there is not a recent case at all. It's a case from 1908, the public trustee in Lowsby. But this was really, for a long time, was the leading authority on the recognition of Māori customary law. And in that decision, the case was about about the payment of expenses associated with the funeral of a very prominent Māori leader. And the argument was that it was Māori customary law that the expenses should be paid out of the estate. Took place there. As it turned out, the case didn't end up turning on that point. But what was recognised in that case was a pretty straightforward, simple test for the recognition of Māori customary law, which was intended to reflect the way in which the common law has recognised customary law in England. And this was essentially to say that, could you prove that there was a particular practice that could be recognised as custom? Was there any legislation that prohibited that practice? And then was it reasonable in terms of the common law? Now, that concept of reasonableness has a lot of scope to it. But the way in which this gets picked up and used in later cases is essentially to say, is there anything that's that's sort of fundamental about the way in which the common law operates that would prohibit or reject this particular practice from taking place? This was, as I say, this was the sort of leading case on the application of Māori customary law for a long time, for really up until the Takamore and Clark case, which I've noted there in 2012, which went all the way to the new Supreme Court. This case was about a dispute over where a body would be buried. So Mr. Takamore had died, and he was Māori. His de facto partner, Ms. Clark, was not Māori. His Māori family from in the Bay of Plenty came down to Christchurch, where he had lived most of his adult life and where he had died. And after some debate and discussion, simply took his body back and buried it in the Bay of Plenty. Now, when this case came initially to the High Court and then the Court of Appeal, both those courts pretty much took the same orthodox approach to recognition of Māori customary law, and both of them, but for different reasons, found that it didn't meet the reasonableness test. In the High Court, the judge said that this didn't align with the kind of common law's emphasis on the autonomy and liberty of the individual. Mr. Takamore had chosen to live outside of his traditional territory. He had told people that he wanted to be buried in Christchurch, and so to override that would go against the principle of the autonomy of the individual. Now, actually, in that case, there was some dispute about what Mr. Takamori had said. It seems that he had indeed told some people that he wanted to be buried in Christchurch, but that when he'd been talking with his family back in the Bay of Plenty, he had told his mum and his aunties that he wanted to be buried back in the Bay of Plenty. Now, that you can imagine a situation where he was saying both of those things to those different audiences. But in any case, the judge in the High Court said that's counter to the idea of this fundamental tenet of the common law of the autonomy, liberty of the individual. In the Court of Appeal, the court, the majority found in that case that they didn't agree that was a reason to prevent the recognition of this particular practice as customary law, because they said that would, because Māori society is primarily based around collective rights and responsibility, that to rule things out for prioritising the collective over the individual would essentially rule out almost all aspects of Māori customary law. However, the Court of Appeal did find that it didn't meet the reasonable test, because they said it was to allow this or to recognise this practice as law would essentially authorise a kind of might over right. Whoever physically took the body and was strong enough to assert that would be entitled to take the body. Now, again, I think there's some questions about how the court is receiving and reading the evidence about what the particular practice was here, because the evidence that gets given notes that there is a process to follow, that there is an important part of that process is to assert your desire to have the body buried close to you strongly, but that a lot of that is performative. And what when people have looked at this case later, they have really come to the conclusion that the biggest problem here was a kind of lack of communication between Mr. Takamori's family from the Māori side of his family, and the lack of communication about what was happening and what the process was with Ms. Clark and their two adult children. But the kind of interesting turn in this Takamori case is when it comes to the Supreme Court. The Supreme Court don't really engage in a discussion about these common law tests for recognition of customary law at all. The Supreme Court begins from the idea that that Māori law, Māori cultural practices are matters which ought to be taken into account as part of the decision-making process for determining where a body would be buried. The Court of Appeal sort of begins that process as well and makes statements to those effect. But in the Supreme Court, we really see it being approached not as whether this can be recognised as customary law and asserted over the common law of New Zealand, but starting to think about actually this being part of the common law of New Zealand, and a source of law that can be drawn on by the courts. And the judgment that goes strongest in this regard was the Chief Justice at the time, who talked about Māori law as being part of the values of the common law of New Zealand and needed to be treated in that way. So that case really marks a turning point from a sort of straight orthodox test for recognition of customary law to starting to think more about how Māori law may be drawn on and treated as law, as the law of New Zealand, as part of the law of New Zealand, rather than having to be proved in a way that you might seek to prove foreign law, for example, or established as a fact of practice. Now, this is really picked up in the Ellis case in the Supreme Court. I'll come back and mention the Ngāti Whātua case in a moment, but in the Ellis case, this was a case, it was a very high-profile child sex abuse case from the 1990s. Peter Ellis had been convicted of a number of offences against children at the creche where he worked. And he had been through a number of appeal processes since that time, and the Supreme Court had granted him leave to appeal, and before the hearing of his appeal could take place, Peter Ellis died. And so the question that came before the Supreme Court was whether the appeal should be continued, given that he had died. Now, when this was being addressed at the hearing, a couple of the Supreme Court judges started to raise questions about whether Māori law ought to have anything to say on this matter, whether we should just go with the assumption that the appeal is discontinued because the appellant has died, or actually whether the common law of New Zealand, drawing on Māori law, might have a different answer to that issue. And the lawyers in the hearing were not at all prepared to engage with that question. This case didn't have a particular Māori dimension to it. Mr. Ellis was not Māori. It wasn't involving a Māori issue. It wasn't about Māori land or governance in any kind of way. But the Supreme Court, from the bench, started to ask, should this be something where we can look to Māori law to see whether that gives us some further guidance about what to do here? Now, one of the interesting things was that the way in which the court then approached this was to engage. The court didn't engage the parties. So the Crown, the lawyer for Mr. Ellis, and then also intervening was the Māori Law Society. They convened jointly a group of Māori law experts, elders, to talk about what would be the principles that would apply and what that they felt, what they determined Māori law would say about this issue of continuance of the appeal. And they took the view that after this discussion, which took place actually at the marae at my university, and very much facilitated by the Māori Law Society as the interveners to address these questions. And they determined that there were key principles around the idea of, again, thinking about the collective interest, that it wasn't just Mr. Ellis who had an interest in his reputation, that he was part of a network, of a community, who also had a right to have these questions addressed, no matter what the outcome was. And they took the view also that because the process had been started, because the Supreme Court had allowed the appeal, then it ought to be followed through to its conclusion, and that until it followed through to whatever conclusion they came to, then things would remain in a state of imbalance. Now, there's a number of other cases there, and I don't have time to touch on them all, but they are all starting to engage with Māori law as law. And so there's a judicial review case there, Sweeney, which was about a decision to revoke a drug and alcohol counsellor's permission to enter the prison, which the court found that actually in the context of Māori law, that has a particular impact on his reputation and his standing, and that needed to be factored into thinking about what the relief was that was provided there in the form of a declaration. There's the Ngā Waka case there, which was about whether an arbitration process could be used to determine who was the beneficiary of a particular trust. And the court said in that case that the arbitration, that was not the way in which you would determine membership of that community. And so the court said they wouldn't enforce a process which was contrary to the law of that community, the Māori law of that community. So there are a number of cases there, and we can maybe talk a little bit more about some particular aspects of them in the discussion. What I wanted to just briefly point you towards, that this is raising some questions about how you engage with Māori law in the courts, and how who gets to be the expert and have the say. Now, there's a number of different approaches that have been applied in those cases. There's been a sort of relatively standard approach of each party presenting expert evidence, and that happened, one example of in those cases with the Ngāti Whātua case. There's the process I talked about in the Peter Ellis case, where a discussion was convened, and this is consistent and quite well aligned with traditional processes for how you would determine what the appropriate application of law was here. You'd get a group of authoritative people together to discuss that matter. And then there's also in a recent case which was dealing particularly with land title in relation to the foreshore and seabed or coastal marine area, a very detailed case which had heard a lot of evidence about this matter. Parties did present their own expert evidence on Māori law in that case, but also the court appointed two pukenga, or two experts, who would also provide a report as well. So there are some different ways there in which the courts are trying to ensure that they are getting authoritative views on tikanga. And the courts, to greater or lesser degree, are conscious, I think, that they are not necessarily the authorities on Māori law, even though they're needing to engage with it and are engaging it with it in a more and more sophisticated way. So really that sort of brings me to these kind of emerging issues that we can see in these recent cases. Very much the courts beginning to engage with Māori law as law in a range of different cases, not only where Māori parties are involved, not only where Māori issues are involved, but simply drawing on Māori law as a source of New Zealand law, as the applicable law in that case in many instances. And that, as I mentioned too, that is seeing a sort of range of approaches to thinking about how you deal with Māori law in a court framework which is not set up to facilitate these kind of discussion based ways of identifying authoritative sources of law, and how you make sure that people with the right expertise are having the say about the application of Māori law. And I want to come back to just thinking about this idea of mana whenua, because I think that's really important, and it's a concept which is coming up through these cases, as I say, not only dealing with thinking about Māori title to land, but what's the authority that's coming with it? What's that kind of legal authority, and what are the implications of the courts trying to get involved in, as they are in the Ngāti Whātua case, of having to determine who has mana whenua in a particular area, and what implications that might have in terms of government action, in terms of who government needs to engage with or perhaps seek consent from in some instances. Okay, that's a real quick run through of some of these issues which are emerging, but I think really just my observation that these cases are now coming quick and thick and fast, I should say, and are requiring, I think, a bit of attention in terms of thinking about how Māori law is being engaged with there. So I'll stop talking, and happy to take any questions or have some conversation.
Thank you. That was really interesting, and I've been making a lot of notes while you were speaking. And I'll open the floor for questions. I should say first, you show what a reckless chair I am, what a shambolic kind of chair I am, because I failed to give an acknowledgement of country. I feel bad about that, and it's just my kind of, I'm a bit slapdash. So I want to apologise for that. Thanks for reminding me of its importance, and to say that certainly those of us who are in Canberra are meeting on unceded Ngunnawal and Cambry land, and I pay my respect on behalf of their elders past and present. So with that, mea culpa put down in the record. I'd like people, if you'd like to ask a question, I would say you can just unmute your microphone and start, or you can send me a chat and let me know that you'd like to say something. I wonder if maybe what we might do, Anne, I see your hand, but Carwyn, I wonder if we could share the screen for the moment, because that would allow us, I think, to see everybody on. There we go. Thank you. That's great. Anne.
Hello, Carwyn, and thank you for a really interesting talk. I was just wondering if you could speak more about how the court is determining whose voice is authoritative, and whether this is one coming from, I suppose, a white colonial court, or whether in the determination of issues around authority, how amplified Maori voices are in that process.
Yeah, that's a really good question. And I think there's, the courts are kind of taking different approaches, and some, I think, provide better scope for Māori voices to be heard. The Edwards case, which was relation to the foreshore and seabed, so in that case, there was lots of evidence from the parties around Māori law, but there was also, as I say, the court appointed to Māori law experts, elders, effectively, to kind of report on those issues as well. So that case, and the court wasn't bound to follow the views of those experts, but having appointed them, recognised them as experts, the judgment acknowledged that they would always be highly influential, and indeed, I don't think the court diverted from what those pukinga, those experts, had said. So in that case, there was quite a surprising amount, actually, of recognition of a Māori voice in that case. It was. I think it was 10 weeks of hearing or something. It was a very long case, involved a lot of parties, and interestingly, the judge who was presiding was not necessarily someone who people expected to provide space for Māori voices, but I think through both the presentation of evidence and through the appointment of those experts, I think that was really helpful in that case. In the Ellis case, one of the things that was really interesting was the way in which the parties initiated getting a group of recognised experts together, and these were really nationally recognised experts in Māori law, and got a group together, and they had 2 days of discussion, and then they produced a statement of, it was a statement of fact as how they described it, and it was one which the parties in that case submitted jointly. And it was interesting the way in which that group of experts, you could see they were really trying to be careful about maintaining the authority over the matters that they have expertise to speak on. And so that's really structured in the sense of, this is, they said, I think they even explicitly say in that statement that they didn't feel it was appropriate for them to provide expert evidence in a way that would be cross-examined, because they're the experts and they are not there to be cross-examined by people who are not experts, was their thinking. And so they provided this statement and they said, look, this is our perspective. This is what Māori law would say about these issues that we have agreed. We're now putting this back into your process, and you can manage that as you see fit. So a kind of recognition that we'll retain our authority over Māori law, and we'll give you our advice on that. But it's not up to you to tell us what Māori law is. And likewise, we're not going to tell the Supreme Court judges what New Zealand state law looks like.
Thank you.
I just wonder if I could just come in on that. And I wonder if you've got anything to say about the politics of the court. So, as far as I understand it, there is now a Maori member of the Supreme Court. He's quite a recent appointment, but I noted that the Ellis case comes after he is on the court. And the idea then that Maori law is a source of law for all New Zealanders, not simply a question of community law, the law of particular community practices and things like that. That's a really significant development, and it's striking to me that happens after Joe Williams is on the court. And I'm just wondering what we know or what you're able to say about both the effect of having, like a Maori person on the Supreme Court, and how the dynamics of the court, those conversations, that collegial environment might affect New Zealand law in the future.
Yeah, no, and I mean, it's obviously very important and significant that we have a Māori judge in the Supreme Court, Joe Williams, and he's someone who has engaged with these questions, or he's not just having a Māori person there; it's having someone who actually is able to engage in these questions of Māori law as well. One of the things that was really interesting in the way in which this issue arose in the Supreme Court was that he wasn't the first judge who started asking questions about whether Māori law had anything to say about the issues in Ellis. It was actually Susan Glazebrook who had been a judge in the Court of Appeal in the Takamore case, which was the burial dispute case that I talked about. And she, I think, probably through that case initially, started to really engage with these questions. The Institute of Judicial Studies, which is the body that runs the kind of professional development for judges here, they have for about the past, well, maybe 7 or 8 years now, have had a training module on thinking about Māori law, which Joe Williams was the kind of key person in designing that. And that, I think, is having a big effect on the way in which judges are are seeing these issues. They're becoming more attuned to thinking about that there might be Māori law issues here. And in the Ellis case, one of the things I think is really interesting or notable is that the Māori law dimension of it, these kind of values, the idea that someone's reputation might be important to their family even though the individual has died, that's not something which is foreign to mainstream New Zealand society. That would be a value I would think most people would recognise, and it's just that the law in that area has kind of become detached from our societal values. And so Joe Williams has talked outside of court about the idea of Māori law sort of acting as a civilizing influence on the common law, actually being able to be used in a principled way to address some of the areas where the common law might have just become a bit misaligned with where our societal values are now. So I know, talking with Justice Williams, I know it's important that he's there on the bench, and it does mean that the court is able to go a bit more deeper on some of these issues than I think it would otherwise be able to. But I know from talking with him that he's talked about the fact that that he's not the one who's having to push those arguments, that there are other members on the bench who are interested in developing the law in that way as well, or exploring how that might work too. It is interesting that the Ellis case is, and I should say we haven't got the court's reasoning for the Ellis case yet. They've agreed that the appeal is to continue and said that they will provide the reasons for allowing the appeal to continue at the time that they release their substantive judgment. But in any case, everyone in that, all the parties agreed that Māori law was relevant to the question of continuance there. It's important that that case has made a statement about the fact that Māori law might be relevant as a source of New Zealand law, no matter kind of what area of law you're working in. Doesn't, just because it doesn't look like a particularly Māori case or involve a Māori person, may still be relevant, and that's important. There have been I know some people, Māori lawyers, have felt a little uneasy about the fact that, well, isn't it interesting that when Māori law can be used to benefit a non-Māori person, that's where we see the law being developed and moving on, and that it kind of takes that step to make that happen. So there is still some politics around this, I think. But yeah.
Another question?
Oh, sorry, I just see in the chat too.
Anthony, yeah.
Yeah, there's the makeup of the Crown lawyers. And right. I think that's important. So the in the Ellis case, the suggestion of jointly convening a group of experts did initially come from the Crown team, and it's notable that one of the Crown lawyers was, their senior counsel, in fact. Through part of that case, the Solicitor General was acting, but aside from them, they one of their Māori lawyers from Crown Law was acting there, and I think that is significant. And I know he drew on his experiences, with his own community, as well as engaging in Waitangi Tribunal claims and work as well, and seeing different processes that might be used to tease out some of these questions.
Yeah. Anthony, you wanted to follow up?
Yeah, sorry, I used a clap, but I mean, a clap's appropriate. Thanks, Carwyn. It's been an amazing talk. It's great to get this kind of rapid introduction to what's happening, and it seems like a lot's taking place. And that's fantastic. Just wondering if you could speak a little bit more to what I heard you say around Ellis, which was the way that the elders or Maori experts essentially treated the court as a separate authority, but not one that had any authority over them. And it seems to me that it's an authority to authority conversation, and their authority, you know, if the court refuses to acknowledge it, in a sense, that doesn't touch their actual authority, which comes from land. It's just the court's failure to see it. That's really a conversation that I don't think we've had, or we need to be having in this country, because it seems to me here about, well, what's the common law going to recognise? But there's never any doubt about who's got control, except there is clearly doubt because First Nations people in this country would similarly, and Ani Malara's here, you might want to speak about this, but would assert it's our authority, you can't touch it anyway. But just in terms of the way the court seems to be actually going, now this is an authority to authority sort of plural laws conversation, which accepts sovereignty to some extent.
Yeah, I mean, I think certainly that's exactly the point that this group of elders was trying to be clear about, was to say, you know, we're happy to give you our advice on this, but let's not mistake, you know, who is the authority in these matters, and confuse that with the authority that you have as the Supreme Court, for example. And you know, I think that there's a really interesting question there. It'd be the Supreme Court in the hearing did kind of struggle with that a little bit in terms of trying to assess, you know, so what is the statement that you've provided us with here, and how can we use it? And so I think it will be interesting to see how they respond to that in their decision, in their judgment. But just one other point on that, and this is more symbolic, but perhaps significant nonetheless. When the new Chief Justice was sworn in, I think she's been in place a couple of years now, and this was our first Chief Justice since we abolished appeals to the Privy, our first new Chief Justice since we abolished appeals to the Privy Council and established the Supreme Court. And at the swearing-in ceremony, the first thing that the registrar did was to come into the court and hand over the authority of that space to the local Māori community to run that process. And that was a pretty big deal because the Supreme Court doesn't hand over its authority to anyone. And although it was simply for the processes of that swearing-in ceremony, which then followed Māori protocols around how you would engage in that process, and with everyone who spoke in that process began even with just a short introduction in Māori, and the Chief Justice took her oath, her judicial oath, in both in English and in Māori as well. And so I think, and so all of that's symbolic, but it does speak to a willingness to think about the visibility of Māori within that space and within New Zealand law.
Great! Wow, that was really interesting, and the relationship between symbolism, authority, and legitimacy is a really interesting one. Anybody else? Another question? We've got time for one more question.
I think I would like to say, Carwyn, that I would welcome your ancestors and the knowledge of your ancestors, the wisdom that has come through to this country. I'm a senior customary law holder here. So that's the short version. It feels very strong what your ancestors are bringing through you for all of us in this place to learn and to grow from, and that we are walking together in this new dreaming. And I speak on my ancestors and the ancestors of this land. I call on you to warmly embrace you. We say nara nara, we will warmly embrace you and your wisdom, and we thank you, Ngānga, for this opportunity to sit in circle together. For it's not just those who've gone before us, it's those who come after us. That's why we're all sitting together. Ngānga, thank you, bless you.
Kia ora, Auntie.
Well, I think that was thank you very much for that. That was a really beautiful, meaningful way of ending up this seminar, and I think that's a great spot on which to stop. Thank you, everybody, for coming. Thanks very much, Carwyn, for what you've said and how you've said it, and for all of the ideas that you've left us to think about. Thanks, everybody.
Thanks.